Hello, I'm Molly Blazek, and I wanted to personally thank you for your purchase on Guardian Connect's EDU platform. The information you're about to receive in this webinar is one of my favorites. I hope you enjoy. The first tip that I want to give you today that you need to know about is about annual reporting packets. You've probably heard me talk about this several times by now, but in April of 2020, some rule changes went into effect. And one of the things that happened is that our annual reporting forms were updated. Now, I don't want to go into all the changes because I've talked about this in previous seminars and previous webinars, but I do want to know, is there anybody on here who is the guardian for a minor? Because I want to talk just briefly about the packets for minors. So I'm going to launch this poll and just see if there's anybody who is the guardian for a minor, because I'm going to talk to you for just a second. Okay, it looks like we've got 100% people in. I'm going to end the poll. There are some of you for a minor. Okay, I won't be wasting my time on this next slide. So looks like 3 of you guys here today are guardians for minors. Okay, so I'm going to touch on something really quickly that you guys need to know about, because this year the annual reporting packets themselves changed a little bit. But what really changed is now the annual reporting packets are separated between adult guardianships and minor guardianships. So for those of us who have any guardianships where we're overseeing the estate or the guardianship of a minor, we have entirely new packets. They're going to look familiar to you. They're not, completely in Latin, but there are 3 questions that I want to point on in the next slide, which are unique to the annual reporting packets for minors. It's these 3 questions. And these were developed because the Forms Committee thought that the information gathered for adult guardianships wasn't really applicable to minors. And so they revamped the forms and asked these questions. So if you haven't done your annual report in 2020 after April, you'll be doing it for the first time before April this year in 2021, and you'll see these questions. They're easy enough, but it asks about whether or not there's a social worker or a caseworker involved, what school the child goes to and what grade they're in. And then there's an opportunity for narrative to tell the court what you want to know about the minor that you want the court to know, what would be important. And these are the pieces of information that are only in the minor guardianship packets. You won't see these in the adult guardianship packets at all. So if you have any questions about the packets, you can always go to the Supreme Court website, and I've got that website on the bottom of this slide. Write that down, screenshot it, do something to preserve it, because this is where you go to get a copy of all of the packets that you need to fill out. Number 2, change of addresses. This one is just going to be really brief. There's a Supreme Court form now that allows you to fill out and complete a change of address notification. And as you can see at the top of this, that would be for the ward, the minor child, the guardian, the conservator, or any interested person. And what I want to note right now is the minor child or the ward, because the reporting deadline for this changed last year. It used to be that you had to report this within 3 days of a move. Now you get 10 days. And I think a lot of people forget this step, especially if you don't use the same mailing address for your ward. Some people use a different mailing address and they think that this is what the court is looking for on this form, and that's not accurate. This form is looking for the physical location of your ward, whether adult, whether a minor. They want to know where they can go to visit your ward if they have to appoint a guardian ad litem or a court visitor, to go see the living conditions, to go interview the ward. So even if you have a different mailing address for your ward, you still need to complete this form and you need to notify the court of your ward's physical address. And this has to be completed now within 10 days of any move. Now, as you can see, a guardian can also use this form to notify the court of their change of address, or if an interested person has a change of address, they can use this form too. But the important thing to know is that you have to do this now within 10 days. And you can file this with your local county court. You can find the form online. It's very simple. If you have questions about it, you're always welcome to call my office and we can walk you through it. but I just don't want people to forget this step. You're not going to be in big trouble if you do, don't worry, but we can't miss this step because we need to be reporting it. A word about budgets. So in April, along with the new packet changes, the way that we do reporting for budgets has changed a little bit. And on the screen, you'll see that I have a page from the budget report. And if you've done your budget report for 2020 and it was after April, then this would look familiar to you. Otherwise, this will be what you're going to use to report your budget going into 2021. Now, budgets have kind of evolved over the past couple of years, and I'm worried that budgets are not the gift. Well, they're becoming not the gift that they used to be. Budgets have always been really, really efficient historically for guardians who have a fixed income for their ward. So typically like Social Security benefits that are the same every month, or VA disability benefits that are the same every month. Budgets get harder when you have fluctuating income and fluctuating expenses. But if you have the same income, and it's usually, Social Security is what we're typically talking about. And if you also have, stable expenses, then budgets have always been something that is really valuable, because it means that you don't have to do a full-blown accounting at the end of the year by producing every transaction that you made on behalf of your ward. The trouble is, with the new way that these are being reported, you'll see that I've highlighted this line. It says, during the reporting year, I have spent the following amounts in the categories listed below. Now, it used to be on the Packet B budget reporting forms that you would have to outline what your court-approved budget was, but then you were asked a question: did you spend outside of the budget? You chose yes or no. And if you spent outside of the budget, it asked you to explain what you did. The thing that makes what I've highlighted so complicated is that if for some reason you did not spend the way that your budget was written, so you spent more or less than a certain line item required, you're going to have to go back and do an accounting to accurately fill out the box below this. And in the first two categories, like housing and food, I don't find that people are having trouble with this. Usually you have a room and board expense, and that's paid to the guardian or some provider. And this is the fixed amount. A check leaves the ward's checking account every single month in the same amount. But where it gets a little bit more difficult is when you have the next two line items and you are, maybe allotted $100 a month for clothing, or, $200 a month for medical and dental. And the amounts aren't what is important here, because I know that in most guardianships, we're not dealing with a lot of money. But what is important is that clothing expenses are variable. Medical and dental expenses are variable. So in order to fill out this budget report accurately, you would have to go back through your 12-month of transactions and total up what you actually spent for this. It's not as easy anymore as saying, okay, I'm allotted $100 a month for clothing. You multiply that by 12 and you get $1,200 and you throw it in the column. That's not what this is asking. So a couple of thoughts about this. Well, I guess before that, let me talk about spending money in transportation. The next two line items that I've highlighted, spending money is probably not as difficult, because usually when we set up budgets, we allocate some sort of dollar amount for our wards to have spending money. For those of us who maybe write a check each month to our ward or get cash to our ward, that's very simple because it's the same amount. We typically follow the budget. We can multiply by 12 and put it in the column that is appropriate. Transportation probably is in the realm of clothing and medical, where it perhaps might be variable. But here are my thoughts about this. If you have to go back and tally up all of your variable expenses, it may just be simpler to do an accounting in the first place, because people who are used to doing budgets don't necessarily track this stuff as much as, or at least they're not as used to tracking this stuff as much as people who have to do accountings. And so if you get to the end of the year and you haven't kept very good records and you have the bank statements sitting in front of you, you might not be able to recreate this in such a way that you can answer these questions meaningfully. The other thing is, if you want to stick with a budget, what I've been telling people to do is consolidate your line items and do it in such a way that there is no variable line item. And I've been inviting clients to come in and have me help them with that and essentially amend the budget so that if they want to keep the budget in their case, they can do it in such a way that it won't be as complicated when it's time to do the annual reporting. Now is actually a very, very good time to do this because with the changes that came in April, we are now allowed to get a 10% variance approved when we have a new budget. So anybody amending an old budget or anybody getting a new budget will have a court order that has this particular language in it. I'm highlighting here that the court authorizes a variance of up to 10% over the budgeted amounts. The point of that was to give guardians the ability to do cost of living adjustments when Social Security increased the monthly amount, by a couple of dollars without having to come back to the court every year and adjust the budget. The goal was to try and give guardians a 5-year stretch of time before they'd ever have to come back and amend. So if you are looking to amend your budget, because of what I just explained about the reporting, now would be an extraordinary time to do it because you also have the opportunity to get this variance approved. Unfortunately, old budgets are not grandfathered in. You have to amend your budget and get this new court order to approve it. But you can absolutely do it and get this 10% variance approved while fixing the problem that the new packets create. And then you should be okay for the next 5 years. I'm going to check in really quickly and see if there are any questions. Okay, we've got one, and it's a good question. The question is, I have never had a budget amount. Do I need a budget amount? And that is simple. No, you don't have to have a budget if you don't want to. Budgets are tools that are offered to guardians if they want to take advantage of that. And usually it's best in situations where you have fixed income and fixed expenses. If you have variable income or variable expenses, then it becomes difficult. And I personally, as a guardian, I'm not talking as a lawyer now, I'm talking as a guardian myself, I prefer just doing an accounting. So the follow-up question to that was, can I just do the accounting report for 12 months? And yes, that is, if you don't have a budget, then you will have to do the accounting for 12 months unless the accounting is waived. Some people have their accounting waived for various reasons, and we don't need to get into all of those this morning. But if you don't have a budget, you typically have to do an accounting unless the court has waived it for some other reason. Okay, I see one more question. I have a waiver where I do not have to do any financial reporting. Can you notify individuals of that? Absolutely. When you are required to do a certain packet, but the financial component of it has been waived, I always just cross that page out on the accounting form or on the annual reporting form for those portions of it that don't apply to me. Now, the new forms will actually cross out for you certain portions of the report if you indicate that your accounting is waived. So on the new Supreme Court forms, if you go to the Supreme Court website and you download them, and that's a tip, here's a free tip, do not work with them from the website. Download them first, otherwise you cannot save your data. I've lost a lot of annual reports that way. I've learned the hard way. Trust me, download it, then work with it. But at the very beginning, there's this new kind of introductory page where you put the name of your ward, you put the name and addresses of the interested persons, and it pre-fills the rest of the document for you. One of the things that you can click is my annual accounting is waived, and then it'll cross out the different parts of the report that you don't have to do. Similarly, if you don't handle any sort of assets for your ward, it'll cross out those portions of the report that you don't have to do. Next question is, what is an example of a time where the accounting report would be waived? Well, the best example that I can give is if you have an individual, and I have many individuals like this, who are receiving Social Security benefits in some way, either retirement or SSI, but they live in a facility who has elected to be their representative payee, and I am not, which means that I am not handling any financial aspects for the person that I'm serving as guardian for. I'm only handling things like medical decisions, placement decisions, things that are germane to guardianships but don't exclude any financial decision making. That would be an instance where I would not have to report on any sort of accounting. Now, this is probably a part of guardianships where if you ask different lawyers, you would get different answers. My dad always jokes that if you ask 3 lawyers the same question, you're bound to get 9 opinions. And that's true. But I've always, as a guardian myself, been very resistant to reporting any sort of financial information for accounts or transactions that I have absolutely no control over. So I know a lot of people, when they're doing their reports and they have situations like this where the person that they're serving for is in a nursing home, let's say, or an assisted living facility, and the facility is serving as representative payee, handling the payment of room and board, giving petty cash through a resident trust account. Sometimes guardians will go get that trust account report and submit it with their annual report to the court. That's okay. There's nothing wrong with doing that. I just choose not to. And I think that the concern for me is that if I'm reporting to the court on transactions that I did not consent to, I have no knowledge of, and now they're being audited as a portion of my report that I've submitted to the court, it's possible that I may have to go down to court and explain a situation that I was never involved with to begin with. So because Social Security funds are governed through the federal government and the Social Security Administration, those representative payees have to do their own reporting. I take the position that the federal government oversees those transactions and any misappropriation and fraud that would relate to that, and not the local county court. So that would be an example of a time when you would have your accounting waived, but not necessarily everybody has that. So sometimes you can elect to just say, I don't handle any funds of my ward. Sometimes you can ask the court for an order that specifically says that you can't handle any funds of your ward, which would change your packet to a packet E. And I know that this is getting into a lot of information outside of what the original question was, but I think it's really good to touch on because everybody kind of has their own way of doing their packets. And I think it's important that you know how I do mine. Another quick question and then we'll move on. I had to fill out a waiver form and then appear before the judge to have her question me. This was several years ago. That would make sense because anytime you're asking for a waiver, you have to apply to the court for permission for it. A waiver would be for an accounting, maybe waivers would be before the guardianship was ever established for the background checks. There are a lot of different opportunities for a waiver to come up, but anytime you ask for a waiver, you do have to get court permission for that. You can't just decide to not do it. Okay, last question. Can we do our forms online? I thought we had to go to the courthouse and turn the reports in person. Yes, you do have to file the report with your county court where the guardianship is, but you can obtain the reporting forms online. Douglas County, and I think now Sarpy County, they're not sending out copies of the forms anymore. So guardians are having to get them on their own, and you can do that through the Supreme Court website. But you do have to physically file it in some way with the county court. Now, sometimes you can fax it. Sometimes that means hand delivery. Sometimes that means mailing. We have portals, attorneys have portals where we can electronically file that stuff. So if you have an attorney, you can have your attorney electronically file your report. Okay, I want to talk just briefly about interested persons because if there's only one thing you pay attention to this morning, I want it to be this. The process for determining who interested persons are has changed. And this is probably the biggest change that has come out of what happened in April of last year. It used to be that when guardianships were established, you listed everybody who was required to be notified in your petition to establish a guardianship. From there, each of those individuals was sent a copy of this form that I'm going to show you on the next slide. It's the Notice of Interested Party form. This form is now obsolete. This form can't even be found on the Supreme Court website anymore, I don't think, because nobody can opt in anymore. You have to opt out. So instead of being able to rely on who your interested parties are based on the filing of this form, you have to start from a bigger bank of people. And if people say that they don't want to be notified, then you can strike them off the list. So I made a list for you guys on the next slide. And I want you to screenshot this or write this down, or I'll send this slide out after the webinar. But these are the people by law who are interested persons. So I won't read them to you, but take a note of this, because regardless of anything that has happened in the case before with the filing of a notice of interested person form, these people now must be included on anything you file with the court. So the certificate of mailing that you have on your annual report, these people or the government agencies have to be listed. Now, there is a process where these individuals can waive notice of certain things. It's essentially limited to the annual reporting. But as an office, we've decided that we're just going to continue to send everything to everyone. It's going to get really difficult for guardians to have to peruse the history of cases to see if somebody, signed a waiver of notice form saying that they didn't want copies of notice, and then look at what they didn't want copies of notices of. And I suppose for people who maybe have one guardianship, it wouldn't be that challenging. But for somebody like me, who, I'm the guardian for about 30 people, that's a lot of, that's just volumes of information when you have a lot of interested persons. And some people want some reports, some people don't want this report. So as an office, we have just decided we're going to send everything to everybody, regardless of whether or not they file a waiver of notice form. I think I've paused long enough on this for you guys to take a screenshot of it. And I will make this slide available after the webinar to all of the attendees. I want to talk just a little bit about serving the interested persons. And then this is my last point. On each of your annual reports, you will have seen a certificate of mailing. I'm sure that for all of you, this is old hat. You've done the certificate of mailing before. I just want to pause here really briefly and just say, just mail it. Just mail the reports. Just mail it to the interested persons. A lot of guardians think that they have to mail it by certified mail or registered mail, or, I get questions like, can't I just hand deliver it? And, yes, you can. You can. There's nothing wrong with that, but it's just overcomplicating something that is so simple if you just mail it. The certificate of mailing itself says that you swear or affirm under penalty of perjuries that you mailed, I highlighted mailed, the listed documents to the addresses set forth below. So if you do anything other than this, you're going to have to make separate notations on this form, and don't overcomplicate it for yourself. Just mail it. Just throw a stamp on it, mail it. This is how you prove you sent it. Just make your life simpler and just follow what's on this form. Just mail it to the addresses that you listed. Okay, I see a question. My ward passed away at the end of October, but the death certificates are delayed. What form do I file? You need to file a notice of death, and I believe that new out this in 2020 is an actual Supreme Court form for that, because I believe I've used it in one of my own cases. So if you go to the Supreme Court website, you'll be able to download and fill out the notice of death. For that notice, you don't need the death certificate. For the motion to terminate the guardianship, you will need it. There was one instance when I could not get it. I could not get it. It was delayed, and I used the obituary instead of the death certificate. So that's another option for you as well. And I'm sorry to hear that your ward passed away. Okay, there's another question. I am guardian of my son. His father, my ex-husband, is currently under a temporary guardianship. The individual filing the temporary guardianship did not include my son, but did include his brother and sister. Should my son and technically me been included on the filing? Okay, so yes, without overcomplicating that question or my answer, When you list in an original petition for a guardianship, you are supposed to list everybody who's entitled to notice, which in this instance would include your son, even though he's under a guardianship. What I think a lot of attorneys forget when they're establishing guardianships is that the statute goes on to read, and you must notify the court if they are under a disability or a minor. So in this instance, your son should have been listed, but it should have been identified that he was under a disability, a guardianship, and that you would be receiving, substitute notice on his behalf. I don't know that that necessarily means that what happened is fatal to the case, but in my opinion, he should have been included.
Thank you again for your download. Each purchase you make on Guardian Connect enables us to provide more resources and more education for caregivers just like you. On behalf of the entire Guardian Connect team, thank you.